Next up, we go to MALEBANE versus JORDAAN NO and another 2024 3 SA 124 GP under the pen of Lagrancy AJ, bundle page 148, and summaries page 12. Now, this one also a bit of an older judgment, but only having reached the SA law reports in this last edition. The issues involved here is whether an adjustment can be effected by a liquidator after divorce. The applicant wanted the liquidator to be removed from the division of the joint estate following divorce. The applicant alleged bias and overreach. And then the court had to consider whether the liquidator's actions were justified and within their powers, as provided for by the MPA and the divorce settlement agreement. The court looked at section 15.9b of the MPA, and it also looked at the actio poliana utilis, which it says was the basis of section 15.9 adjustment claims. Now, folks, 15.9 essentially being if you are married in community of property and you enter into a prohibited transaction and the joint estate suffers loss, you can be ordered to adjust to make right with your spouse on divorce. So if the joint estate suffers loss of 50 Rand due to a loan entered into, for example, you would have to compensate your spouse by 25 Rand in their favor so that they don't bear that 50% of the loss. And the court's ratio was the words by die verdeling van die gemeenskaplike boedel should be widely interpreted to mean in the process of the division of the joint estates, which starts with a decree of divorce and which ends after actual distribution. Thus, in this instance, because the court order made provision for it, the liquidator having the power to effect those adjustments in terms of section 15.9.